Okay, I've logged in and made you and that computer a co-host. Did you hear? Okay, we're recording now. Okay. So I'm sure we've had this discussion before on the TDS, but it continues to be, or I should say, there are a lot of questions about when it's required and the ramifications of the TDS itself. So a couple of questions we're going to address today. Are there any transactions involving 1 to 4 unit residential property for which the seller is exempt from providing a TDS? What should either the listing agent or selling agent do if the seller refuses to complete the TDS? And what should you do if you realize that the seller has completed the TDS incorrectly? And then is it mandatory that a TDS be provided to a buyer, or can the buyer waive his or her right to receive the form? So the TDS is addressed under Civil Code Section 1102. Requirements of the TDS are as follows. It stipulates that a seller of residential property with 1 to 4 dwelling units, including personal property mobile homes, meaning it's not a fixed, and manufactured homes, provide a buyer with a specified disclosure form about the property. And that's the TDS, the form we use satisfies that requirement. And then the TDS it's just a statutorily defined form. That's all it is, required by the Civil Code. And then it states that if the disclosures or any material amendment to the disclosures are made to the buyer after execution of the offer to purchase, the buyer has 3 days after personal delivery of the disclosure form to cancel the contract, or 5 days if the form is delivered via mail or electronically. Provides that neither the seller nor real estate agents are liable for any error or inaccuracy in the disclosure form, provided they had no personal knowledge. So the key term is provided that they had no personal knowledge. If you have knowledge of inaccuracies and you didn't read the form and notify all the parties, you could be responsible. And then should there be more than one real estate transaction or one realtor involved in the transaction, the person obligated to deliver the TDS to the buyer is the buyer obtaining the offer or the selling agent. And then provides that a transfer of real property shall not be invalidated by failure to comply with the disclosure requirements. So once again, let's go over the TDS itself. Section 1 provides space to list additional existing disclosure reports that the seller may have in his or her possession, such as property inspection reports, pest control reports, so on and so forth. Section 2 is just a vast checklist of items describing the properties, the pool, sump, pub, so on and so forth. And there's additional space for the seller to disclose material items. And then sections 3 and 4 are to be completed by the listing agent and selling agent, if there are both two agents involved. And section 5 contains the signatures of the parties and their agents. So what are we supposed to do? Well, of course, we use the form AVID, and it should be used by both the listing agent and the selling agent. The AVID is not required by law, although the inspection, the visual inspection, is required by law. Keep that in mind. I'm sure you all know that. And of course, the AVID was created just to simplify the inspection process and to make it much more systematic. So remember, when completing the AVID, if there are 4 bedrooms listed on the AVID, but you have 2 bedrooms, you should simply state NA, not applicable, for those spaces that are to be left blank. If you don't see anything, then you should write no visual material defects. I see so many people from other offices writing good, wonderful, good throughout every single line item. Now we know that that's not possible. And then properties covered by the TDS, it applies to transfers by sale, exchange, installment, land sale contract, lease with an option to purchase or an option to purchase, or a ground lease coupled with improvements of real property, or a residential stock cooperative, such as in Laguna Woods, improved 1 to 4 dwelling units. And it also applies to manufactured homes and mobile homes classified as personal property. Is the TDS required for mixed use property? So yes, it is. The overriding factor in what regards whether you are required to provide a TDS relies on the fact, is it a 1 to 4 unit residential building, or is one of the buildings or aspects of the property residential in nature? That's the defining factor. So there are transfers that are exempted from providing the TDS. Transfers requiring a public report. So for example, a new builder's tract, right? They provide the buyer with a public report. Transfers pursuant to a court order, such as a probate sale or sale by a bankruptcy trustee. Transfers by foreclosure, including a deed in lieu of foreclosure and a transfer by a beneficiary who has acquired the property by foreclosure. And an example would be a bank that foreclosed on a property and they are reselling the property. That entity is not required to provide a TDS. Transfers by a fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. So the exception to that would be if the property, for example, is held in a revocable trust and the trustee is a natural person who is also either the former owner of the property or is an occupant in possession, then they are not exempt. So let's give an example. I transfer my property into my revocable trust. I have an obligation. I'm selling the property. I have an obligation to provide a TDS. Let's assume my property is in my trust and I unfortunately am now deceased and my beneficiaries are now acting on behalf of the trust. Assuming they haven't lived on the property during the last year, then the estate is not provided or not required to provide a transfer disclosure statement. So the other thing we see many times, there are small infill projects or maybe an investor who has built a new home. If there isn't a public report, most likely that seller or builder is going to be required to provide a TDS also. TDS is also applied for sale by owners, so they don't have an exemption. And then who fills out the TDS? Well, sections 1 and 2 of the form are for the seller to complete. Please never fill in the form for them. Section 1 gives the seller the option of satisfying the TDS disclosure obligations through substituted disclosures in lieu or in addition to the TDS questions themselves. So if we take a look at the first page, you can see, would you show the very top of the form, please, Carlos? Thank you. So a couple of things. You can say 1, 2, 3, 4, the 5th line down. You should insert the date when the property was inspected by the person who completed the form. And then keep in mind that the purchase contract, we always wonder what's the issue about the TDS in regards to completion. When is it actually complete? Because remember, if you deliver an incomplete TDS, it leaves the rescission period open for the buyer. So let's define what a complete TDS consists of. Well, first of all, if we look at section 11A2 of the purchase contract, it says the real estate transfer disclosure statement required by this paragraph is considered fully completed if the seller has completed the section titled coordination and with other disclosures forms by checking a box in section 1. What box are they talking about? Well, there's the item of no substituted disclosures for this transfer. You should check one of those boxes, that one or 2 of those above. Now, the 2 above is not going to make it, it's not going to cause the form to be complete, but we must choose the box for no substituted disclosures. I've not yet come across a transaction in which there are substituted disclosures in lieu of the TDS. So if you don't check that box and you're not giving substituted disclosures, the TDS is not considered complete. Section 2 should be complete. If you would move the form up, please, Carlos. Thank you. So we check the boxes. It's real simple in that regard. Keep continuing down the form, please. So we just continue to check the boxes and then stop, please. Stop, stop, stop. I need to see the very top of page 2. Thank you. Now, if we look at section B, it says, are you seller aware of any significant defects or malfunctions in any of the following? Well, defect sounds like a nasty word, doesn't it? What's a defect? Well, maybe I replaced an AC unit, or maybe you had my AC unit repaired. That could be considered a defect, so keep that in mind. So help your clients understand that they should be checking the box, over disclose if necessary, not necessary, when at all possible, as a matter of fact.
You discussed, or give an example of the running rescission period being open again, or for those that might not understand what that means?
Sure. Well, Carlos is asking for an example of when the rescission period may be reopened. Well, theoretically, the rescission period begins upon delivery of the TDS. So we have 3 days delivered personally, 5 days electronically or via mail. So I have now submitted the TDS. The 5 days has passed. My client has removed all contingencies, or the buyer has removed all contingencies. Now the seller discloses or finds out that they made an error on the TDS, and it's a material error, and it causes them to redisclose. Well, at that point in time, upon delivery of that amended TDS, it gives the buyer the opportunity to rescind the contract. And they have up to 5 days. Usually we seem to manage our transactions electronically. So they have 5 days following delivery to rescind the contract if there is an amended disclosure. The other thing, so we talked about the rescission period. There are other disclosures in the purchase contract that are referenced that are deemed to be statutorily required disclosures that also have a like rescission period. So if we look at the contract, that's going to include the NHD report. So you're a listing agent. It's critical that you deliver that in a timely manner, because if you deliver it later, let's assume you deliver it on day 10 and they removed all contingencies, and then one of the boxes is checked that it's in a high fire zone. Well, I would say that the buyer probably has a valid opportunity to rescind the contract without being in breach. So that's one of the disclosures that's required. In addition to that, lead disclosures. So that is required. You cannot, and it's void and against public policy to suggest that it's not a part of the contract. The home fire hardening disclosure and advisory, and the defensible space disclosure and addendum. It's all one form. Once again, that can open up the rescission period, or it opens up a rescission period upon delivery. So it's important that those forms are delivered when required. So that's all under section 11A, B, C, and D of the purchase contract. So those various disclosures will give the buyer an opportunity to rescind the contract. And that can even also apply to things such as military ordinance, a Melrose district. So those are all disclosures that are required statutorily that could open up the rescission period, or allow it to remain open if we don't send the required disclosures to the buyer. Yes.
Question from Marty. She's asking, it says significant defects. How significant does it have to be?
Well, that's a good question. What would you consider significant? Every buyer has his own definition. If it's a light bulb that's out, I would say that that is not material. That would not require redisclosure. That's a good question. I think it's going to be based upon the individual themselves. If there's a death on a property, it wasn't disclosed, ordinance in the area. Common walls, maybe the fact that there's two associations and the seller didn't disclose both. They only notified escrow one. So of course, the buyer's only notified of one HOA.
Hey, Richard, what about when they remove asbestos or mold? Do you put
Those
it
are
in
good
the
ones,
class?
right? As a matter of fact, removal of that. So just because you've had it removed and you have a certification by somebody's licensed to do that, I would suggest that that's something you should be disclosing. And could that be considered material even though the issue has been remedied? I would say it could be considered material, and it could be a valid right for a buyer to terminate the contract without being a breach.
I have a question, Richard, if I might.
Sure.
I've had a circumstance with this TDS situation of a person dying, death through a murder out here, and it blew a deal up. But you have to disclose things like that, don't you, in that TDS?
Well, or the seller property questionnaire, right? You have an obligation statutorily to disclose this. So remember, there's a 3-year period to disclose a death on the property.
Okay.
Now, I think John brings up a good question. So what if it's a violent death and it's beyond the 3-year time frame? I'm going to disclose that because that is a material event. Even though the law theoretically insulates the seller from disclosing that, I would always disclose that. If it's a something that just a natural passage, it's probably beyond 3 years. There's no required disclosure. However, what if you're directly asked that question? So say 10 years ago, somebody died in the house, and now you, the seller, or you, the listing agent, are asked the question whether or not somebody passed away in the property. You have an obligation to be truthful and disclose that.
Okay, was a few years ago, but still, this has brought up the thought and process in my head about it.
Yeah, it's very important. I would not risk not disclosing that information.
Yeah.
So if we've given a disclosure, we've given the TDS, and let's find out, or maybe we find out that something wasn't answered properly. Should we amend it? Absolutely. We should be amending that. And what's your obligation as the agent? Should you be reviewing those disclosures before giving them to the other party? I would say absolutely yes. Remember, you're not responsible for information of which you are not aware of. But in many cases, you probably have knowledge and information in your mind that would contradict the information that the seller's provided a buyer. So could you be held responsible? Absolutely. And then not only that, you have a fiduciary obligation to your client. So you should be reviewing all of those disclosures to be sure that they are accurate. And in the event the seller does not wish to amend the disclosure or change a response that you believe is incorrect, you should disclose your information on the ABID. So you can submit conflicting information to a buyer. If that's the truth, that's what your obligation is. And then how about relocation companies? So if the reload company bought the property from the seller, actually, what's the obligation? Reload companies have no exemption from providing a TDS. So what should be taking place, if you're a listing agent, you probably have worked with the person who actually owned the property before it was acquired by the reload company. You should acquire all the disclosures signed by that seller that should be attached to the reload company's disclosures to provide that information. There's case law in which the prior owner, because they didn't give the disclosures, was held responsible for issues that came up later on. So you should always get that original information from the property owner who sold to the reload company. If you're representing the buyer, you should be insisting on getting that information.
What happens if the relocation doesn't provide the information? You're the buyer and something.
So if they refuse to provide the information, I would say that, or any disclosure that the other party refuses to provide, you should be notifying your client in writing and have them acknowledge the fact that they are not receiving the required disclosures.
But it's something where a month later that was pre-existing
Condition, right? I mean, a defect in the property that the original owner knew of and it wasn't disclosed by the reload company or that owner, they're both going to be sued. Yeah, they're both going to be held responsible. And then, so remember, completion of the TDS. The TDS is considered complete when you check one of the boxes under section 1. You answer all the questions, so check the box for no substituted disclosures. If you leave that blank, then the TDS is not considered complete. So don't put yourself in a position where maybe somebody technically can tell you, no, you never delivered a complete disclosure, thus the rescission period remains open. So let's not put ourselves in that position. And then farther on down, you can see all of the check boxes. And let's just go through some of the check boxes, because I think sometimes there are questions about how we would properly fill that out. So section C1, substances, materials, or products that may be environmental hazard, but not limited to. Here we are, Carmeza, asbestos, formaldehyde, radon gas, lead-based paint. So if it's a pre-1978 property, it's likely that there's lead-based paint. You may not know that, but you should disclose it if you're aware. Obviously, if there is ever asbestos, removed or not, mold on the property, addressed or not. And then this is always a common one. Features of the property shared in common with adjoining landowners such as walls, fences, and driveways. Irvine has a lot of shared driveways, a lot of shared common walls, both from a fencing standpoint and the property itself. Laguna Beach, for example, has roads that must be maintained by all the homeowners living on that road. So there's shared responsibility there. Encroachments or easements. And then the next one, room additions, structural modifications, or other alterations or repairs made without necessary permits. Obviously critical, the next one, repairs not in compliance with building codes. I don't know if people would know they were or weren't, as a matter of fact. Section 6, fill, compacted, or otherwise on a property. That's pretty self-explanatory. Any settling from any cause or slippage, sliding, or other soils problems, flooding, drainage, or grading problems. Major damage to the property from earthquake, that's a simple one. Zoning violations, non-conforming uses, violations of setback requirements, neighborhood noise problems, or other nuisances. What if there's an airport or flights coming in over the property, for example? And here's 12 and 13, and these are commonly misunderstood. CC&Rs or other deed restrictions or obligations. And then 13, homeowners association, which has authority over the subject property. Now there can be CC&Rs recorded, but there isn't necessarily a management company. So how would you know that? You should be looking at the preliminary title report, and the prelim is going to tell you if there are CC&Rs. And then you'll also find out if there is an HOA in place, because the seller should be disclosing that. So just because there isn't a management company doesn't mean that there are not underlying CC&Rs. And then another one that's answered incorrectly, often homeowners association, which has any authority over the subject property, common area or undivided interest with others in any condominium there's going to be. Notices of abatement or citations. And then the next one, 16, any lawsuits by or against the seller. So it goes beyond that, as a matter of fact, and a lot of this is associated with a required warranty that builders are to provide via statute. So let's assume that a homeowner bought a new home, and then they don't actually sue the builder, because every purchaser in a tract today agrees to go through a process that is not actually litigation. So if they make a claim in regards to a defect, that's something else that they should be disclosing, as a matter of fact, to any buyer. And if we look at the top of section or page 2, seller must sign, right? And then section 3, agent's inspection disclosure. So the agent should want to do one of the 3 items, complete the AVID, or write in the information associated with their inspection under section 3. So when we deliver that and we've completed sections 1, 2, and 3, the TDS is considered complete. Any questions about that? Let's see. And then in terms of when the TDS must be delivered, well, the contract indicates that all the seller disclosures are to be delivered within the first 7 days of the purchase contract. And then a lease option, if you were to enter into a lease option before the lease option is signed by the buyer, the TDS should be delivered before then. What happens if a TDS is delivered before a purchase contract is submitted? Is there a right of rescission? No, there isn't. But subsequently, the TDS is amended, it would open up the rescission period. So, about that. And then, can a buyer waive his or her right to receive the TDS? No, they can't, as a matter of fact. So you have to deliver it. And once again, if the seller refuses to fill out a TDS, it leaves the rescission period open through the close of escrow. You can close escrow without a TDS, so that's not an issue. You can't rescind a transaction that's closed because the TDS was not delivered. And of course, there's always liability for the seller for not providing the TDS. And then once again, will a seller or real estate licensee be liable if the TDS contains inaccuracies or omissions? Well, not so long as the following are true. The errors or omissions were not personally known to the seller or the licensee, but that's the question. Not personally known. Or you relied on some third-party information or reports or governmental reports, for example, engineering reports. So that would be a valid reason why the information you provided, you believe to be accurate because you relied on some type of third-party report. But once again, it's critical that you read all of those responses and help your clients fill them out. It's overwhelming for them in trying to complete those disclosures. And for the most part, they're incorrect or they're not completed. So don't allow yourself to be in an awkward position by not fully completing the disclosures. And then what about a property?
I have a question.
What's
yeah.
that?
In regards to transaction, if the TDS is not provided, is there any forms in zip form that we can sign as a waiver or something like that to protect us going forward?
No, not that I'm aware of.
Okay.
So I would just probably at minimum get an email which they acknowledge it.
Okay.
I'd say an addendum which say something that they've signed acknowledging that the seller has not provided those disclosures.
Okay.
Anything written, I would think, acknowledging the fact that the seller has not provided them and the buyers acknowledge not receiving them. And it should put them on notice, actually, if there might be something wrong. It makes you wonder why you would not provide it. But it's interesting. And we, one of the agents in our office was jointly listing a property in Santa Monica. And the only reason he was jointly listing it because we're located here and the seller wanted somebody who was local and it was a Compass agent. Well, they didn't think the seller for some reason had to provide the TDS. It was an argument. Not sure why. It was an investment property. So those are questions, for example, that come up all the time. If it's an investment property, must the seller provide a TDS? Yes.
Yeah.
Does it matter if the seller's ever occupied the property or ever saw the property? No, it doesn't matter. They should provide the TDS. So if it's a corporation, doesn't matter if it's domestic or not within the state, they must provide a TDS. Individuals, revocable trust. So those are all circumstances in which a TDS must be provided. It's rare that a TDS is not required, as a matter of fact. So people think sometimes because they're investors, they don't have to provide a TDS. That is completely inaccurate. And then if a TDS is not required, remember, you're going to have a separate obligation to complete the smoke detector and water heater compliance issues. That is addressed in the TDS. So it saves you time, actually. And once again, in terms of lawsuits, so when section 16 of the TDS, it could be fit and finish issues associated with a house that somebody acquired through a builder. So if they were to go through those non-litigation requirements or stages, that should be disclosed to any buyer of that property. Does anyone have any questions about that? Is there somebody in the chat box? Is there? All right, those are already in there. So remember, when looking at the purchase contract, we talked about the right of rescission and the other statutorily required disclosures that also have the same rescission period would include lead disclosures, the home fire hardening and disclosure, the FHDS, for example. I know that's very difficult in terms of when you look at that form. It's complicated. It's not necessarily clear. And then also the NHDA report. And I think the NHDA report is much more critical now than ever. Everybody may be aware that State Farm is no longer writing or underwriting new homeowners policies. And then Allstate made the same announcement. So State Farm had 20% of the marketplace in California. Allstate pulled out in regards to writing new homeowners policies. It's going to be becoming more and more difficult to get homeowners insurance. And if you're located in a high fire zone, it's going to be that much more difficult and certainly much more costly. So when you're representing a buyer early in the transaction, you should be speaking with your client to let them know that they should be finding out what those premiums are going to be for that property.
I have one on the transaction I'm doing out here, $650,000 purchase. The quote came in from the insurance company yesterday that's on that risk state risk policy wrap, $5,600 per year.
For a $650,000 property. Yeah, it's crazy.
Yeah, yeah. So just let you know.
That's what's happening, right? Supposedly the fires and litigation. That's one of the biggest issues that's taking place. So that's why they're stopping writing policies. And then the other things that add to the rescission period, Melrose assessment districts. And then whether or not you're in an industrial use or military ordnance location. So what does that mean when you look at the NHD report also? It talks about being in an industrial area or a commercial area. That could be the local strip center, but that could be a yes response on that NHD report, and that could affect somebody's decision. So you can see why that NHD report is so important, that you provide that to the buyer as soon as possible, so we can remove their ability to rescind or cancel the contract upon delivery of that document. Okay, well, that's the end of my discussion for the day. Does anyone have any questions? Okay, well, no. Thank you very much for coming. I'm happy to see everybody, and I hope you have a great day.
Thank you.
Thanks.
Thank you.